Hello, dear participants, and welcome to Cobalt Pan-Baltic webinar on Pay Transparency Directive, where we will discuss the requirements of this directive, what employers need to do to prepare, and also look into the relevant case law. My name is Alisa Artamonova. I am a lawyer from Riga office in the ESG practice group, and today I'm joined by my colleagues, labor law experts. We have Hailey Habu, senior associate from Tallinn office, Kristiina Patmalniece, specialist counsel from Riga office, and Jovita Valatkaite, associate partner from Vilnius office. So before we begin our presentations, I need to share some technical information as usually for webinars. So please note that this webinar is being recorded and we will make the recording available later for everyone to rewatch if necessary or share with their colleagues. And second thing, we will not be sharing the slides. But since there will be a recording, you'll be able to see those in the recording. And we also would like to welcome you to ask questions about the topic of the webinar. You can ask those in the live stream comments section, and please ask them at any time of the webinar. I will be reviewing them, and towards the end of the webinar, we will have a Q&A session where our experts will try to answer as many questions as possible, time permitting. So, yes, so I'll give a very brief and quick introduction to the webinar first to explain why do we even have this directive and what is it trying to address. So this directive is trying to address an issue that we have in the EU, but actually it is also broader and concerns many countries, is an issue that women are generally paid less than men. And this issue persists not only because women tend to maybe have lower paid jobs, but also because there is still inequality in wages and women tend to be paid less for equal work or work of equal value. And interestingly, this directive does not prohibit per se unequal pay because it has been prohibited already for a while in the EU. Already since 1957, the Treaty of the Functioning of the EU has this prohibition and the principle of equal pay for equal work and work of equal value included. And for example, in Latvia, it is Article 60 of the labor law where this principle is also inscribed. But unfortunately, having only a prohibition in the law hasn't brought the results, the desired results, and therefore the EU has decided to take next steps and introduce this Pay Transparency Directive, which you can say introduces requirements for employers to show to their employees and to wider group of stakeholders what actually is the situation in the company with the pay and gender pay gap. And therefore, these rules will start applying in exactly 1 year and 1 day in June 7 of 2026. But to show you what is the situation in the EU, I've pulled out some statistics. And unfortunately for Latvians, we have the widest gender pay gap in Latvia, which stands at 19%. And it means that, for example, where a man would earn 1,000 euros, a female would only have 810 euros. Then situation in Estonia is slightly better. The gender pay gap there is 16.9%. Then the average in the EU is 12%, and Lithuania is just below that with 11.5%. And interestingly, as you can see here on the graph, there is one country in the EU that has a pay gap of minus 0.9%, and that is Luxembourg, which essentially means that in Luxembourg, women earn slightly more than men. And one last slide for me before I give floor to Haley. I wanted to show you that in the EU, the gender pay gap is also measured by sectors. And as you can see, we have manufacturing where the pay gap is quite large, also information and communication. But in fact, the largest pay gap exists in financial and insurance activities, where it can reach even more than 30%. So thank you. That's it from me for now. And Haley, please continue. Haley, your microphone.
Yeah, sorry. Hello to everyone. Let's look more closely at the new directive then. So the first slide is about the scope of application of the directive and who does it apply to. It's a very wide scope of application, so it will apply to all employers of the EU, both in the private as well as the public sector. And it also covers all employees who qualify as employees under national law. So this means that part-time workers as well as full-time workers, workers on fixed-time contracts, even employees who are engaged through temporary agency, platform workers, trainees, apprentices, whoever is deemed an employee under national law is taken into the scope of that directive and has the information rights and the right to pay equality. The directive does not, however, apply to service providers. So if there are any natural person service providers, then they do not come under the protection of the directive and they have no information rights. There's no need to compare their salary levels. Now, we will see later that certain obligations arising from the directive relate to specific employee numbers. But that does not mean that if you are a small employer with less than 100 employees, then the directive would not apply at all. The directive still applies to all employers, except for certain reporting obligations to public authorities. So yes, these obligations are only limited to bigger employers, but the need to provide information to your employees about pay quality, the need to establish gender-neutral pay criteria and introduce those, this applies to everyone. And finally, when we are speaking about pay in the pay transparency context, then we should also look into what qualifies as pay within the meaning of the directive. And it is to be noted that the pay is to be interpreted very widely under the directive. So it does include, obviously, the basic pay, but it also includes any other payments, whether in cash or in kind. So it's bonuses, overtime pay, travel allowances, sick pay, it's even food and accommodation vouchers. So anything that is given to the employee, compensation for work in the employment relation, comes under the scope of this directive, and sort of equality needs to be ensured. The first right under the directive that we're going to look into is the employee's right to information. So under the directive, employees have the right to receive information about their pay level, as well as the pay of their category of employees, both before and during their employment. Candidates to a position can no longer be asked about their previous salary. So in the job interviews, this question can no longer be made. And the employer must provide information on the initial pay for the job, as well as the pay ranges based on objective criteria. So this must be done before employment. It can be included already in the work ad, or this information can be presented during the interview, and then also later during the employment, the employee has the right to have this information. The employer must explain both the pay ranges as well as the pay progression, so the principles of pay increases, which must be objective and gender neutral. And among other things, also soft skills must be taken into account in establishing the criteria. So the pay progression should be based on objective criteria such as seniority, skills improvement, and increase of efficiency, for example. Under the directive, the employees have the right to know their personal pay as well as the average pay of comparable employees by gender. And if an employee requests this information, it must be provided within a reasonable period, which may not exceed 2 months. The employees may ask for this information personally, or they can also ask for it through their representatives. So it can be an employee trustee or a trade union filing the request on behalf of the employees. And finally, it must be noted that it is the employer who must inform all the employees of their right to the information. So even if the employees are not aware of these rights, then it's the employer's duty to inform them of the new rights arising from the directive and the Local Implementation Act. Now, the employers who have at least 100 employees will also have certain reporting obligations to the national authorities. It means that they must notify the national authorities of the pays and the pay gap in the company. And if the pay gap in the same category is more than 5%, and then there is no objective justification to that pay gap, the employer needs to close that gap within 6 months. Or if that fails, then that triggers a joint pay review, which must be carried out with the employee representatives. Jovita will give more detail about this process later on, but it's something that probably most employers would like to avoid. So it's critical to ensure that objective criteria is well established in the course of this pay reporting, if any differences occur. And although the directive will enter into force next year, then the reporting obligation is not immediately triggered, so you will have some time to prepare for the reports. And depending on the number of employees, the reporting obligation will be either annual or every 3 years, and the first reports will need to be filed in 2027, while smaller employers can still wait until 2031 with the first reporting. And smaller employers who have less than 100 employees, they can file the reports voluntarily if they wish, but there will be no mandatory reporting to public authorities. But they will still have to provide the information to the employees. So when we're speaking about the pay gap, then one of the key terms here is categorization, because it's essential to understand what constitutes equal work within the meaning of the directive and the EU law. So the categorization is important for all employers, regardless of the number of employees, because that's also the basis of establishing a gender-neutral pay system and reporting the information requests of the employees. Categorization means identifying roles of equal value. So when we are speaking about roles of equal value, then we're not speaking about financial value or market value. We are speaking about jobs which have the same value, looking at the skills and requirements and the value for the employer. So there are these four main criteria that have been established under the case law of the Court of Justice, which constitutes skills, effort, responsibility, and working conditions or working environment. It does not mean that all of those are equal. So depending on the position, one may be much more important than the other one. So you should sort of be able to indicate a percentage that this particular criteria forms for a particular position. And it's not an exhaustive list. So depending on the position, there may be other criteria that is relevant or critical in that specific position. But these are sort of the main four criteria that need to be taken into account. When we're speaking about the categorization process, it is obvious that it is complex and it's not entirely objective. So at least in Estonia, we are expecting the state to go and give some instructions to the employers of how they need to go into this process. And training should be available starting from December 2026. It could be that some EU general instructions will also be issued, but at the moment these are not available yet. So when we speak about categorization, then we sometimes hear back from our clients that, okay, but we already have a job gradation system in place, and do we need to change it? So the answer is that if you already have a gender-neutral job categorization or grading system in place, then the directive does not trigger a change of that system necessarily. So it should just be checked whether the current system is adequate in the context of the directive, whether it takes into consideration all the relevant criteria. And if that is the case, then you may well continue with the current one. There's no need to change it. But if there is no such system in place, or it doesn't consider maybe all elements or soft skills, or then you may need to look into this and modify it. I'm going to give floor to you, Vitana.
Thank you. Right. So usually there is one misconception that we encounter when we speak with the clients about this directive, is that the pay gap cannot exceed 5%. And this is not entirely true. In fact, the pay gap should not exceed 5% if there isn't any reason attached to it or a good reason for having the gap. So, depending on how the employee's jobs are evaluated, if there is a reason attached to a specific pay gap, then that pay gap could exist. So, in general, pay gap assessment is a fairly complex process, and depending on the information reported, a joint assessment of the pay gap may be triggered, and it is quite a complex statistical and resource-intensive process, so we generally recommend to avoid it. But let's say that you encounter a situation where an employee has a 15% gap compared to another employee. So if you are able to explain that 5% is caused by, let's say, an objective factor such as experience, and 6% is caused by another objective factor, while the rest does not exceed the 5% threshold, you could in fact have such a gap in your company. However, usually problems occur when we are assessing which factors have influenced the 5, the 6, or the 7%. Several different models can be used in this assessment procedure, and employers should be able to explain the method they have chosen. The employers are free to choose any method they desire. However, it should be logical. You should be able to explain it not only to the employees themselves, but also to the authorities and employee representatives. And then it should be clear to everyone how you came to the conclusion that the gender pay gap does not exist or it does not exceed the acceptable threshold. And in the end, you should also explain why you maybe did not report it following your chosen methodology. Employers should always be aware that the burden of proof is on them. So whatever methodology they choose, then they should be able to prove that this is the right chosen method. And again, it should be taken into consideration not only salary indicated in the employment contract, but also other benefits should be assessed when you are trying to decide whether there is a pay gap in your company or not. So talking about benefits, it could be anything that is quantifiable in money. So additional allowances. It could also be vacation indirectly, such as in this case that is mentioned in the slide, which we have had in Lithuania a couple of years ago, where a group of employees who belong to a trade union received annual leave of 28 days, while the other group, who did not belong to the trade union, was granted a 30-day annual leave. Of course, all of that leave was paid by the employer. It is quantifiable in money, and the court decided that, unfortunately, this is discrimination of one group of employees compared to the other group, and the situation should not occur. So, this is a good example on how you could take into consideration all of the benefits that are used in the company. So again, another question that occurs for the employers are sanctions, because everyone wants to avoid the sanctions and the monetary effect that may influence our decisions. So under the directive, member states must apply effective sanctions which would deter the employers from following the practices of discrimination in terms of gender and pay. The sanctions could be a percentage of the company's turnover or a certain percentage of salary expense. And the victims are given the right to claim full compensation, both for the pay gap and for non-pecuniary damages. So, for example, they could claim that this pay gap caused them stress, they were not being valued to a sufficient extent, and they suffered discrimination. And member states should ensure that trade unions or employee representatives can also bring such claims on discrimination in terms of pay, and they are not being disadvantaged in another way. So courts, when claims are filed, can take interim measures. This means, in a very legal language, that basically the courts can freeze a specific situation or may ask the employers not to do something. So even before the case is resolved, the effect could be immediate if the courts take and apply these measures. And member states may also decide that the costs of the proceedings, once the claim is brought up in court, are to be recovered by the employer, even if the employer wins the dispute. So usually we have a principle where the party which wins the dispute, it doesn't have to cover all the fees for the legal proceedings. These fees are recovered from the party who has lost. However, in this case, in this situation, the directive says every single employee should be able to bring a claim to court, and they should not be placed in a situation where they fear to bring a claim in court because it may cost them a lot if they lose the case. Litigation is quite expensive all across the Baltics. It is a difficult and complex process, so some employees may be deterred from that. So the member states have a possibility to choose that even if the employer wins, the employer has to foot the bill. And failure to comply with the directive can also lead to exclusion from public procurement procedures, which means that if it is decided in a court procedure or in a different situation that in fact the employer did not comply with the directive, not only a fine could be applied to that employer where they will have to pay a specific sum of money, but there could be some secondary consequences, which means that the employer will not be able to participate in public procurement. For a portion of companies, this could be a very significant secondary effect. And we have a similar effect in Lithuania where it is found that the employees were working under illegal conditions. So illegal work is detected, then similar consequences occur. So this may extend to other Baltic states, and we will see how the sanctions are structured once the directive is transposed all across Baltics. And now let's take a closer look where we are on the calendar in transposing this directive. So in Estonia, no draft law is available yet. I think that the authorities are working very hard on drafting the law, but we are still a little bit ahead the timeline. So it is expected that the draft law will be published this summer. Practical instructions for evaluation of work and pay categorization are expected to be drawn up by December of this year. So first we will have the law and then some quite specific instructions on how the work should be valued and as Haley discussed, how we should take into consideration whether specific work is of the same value or not. The state has also developed a digital tool to assist the employers for monitoring the pay gap. It is called Pay Mirror. I will not attempt the name in Estonian. I don't want to butcher that, but it is already available online and the Labor Inspectorate uses it and the data that is already submitted in the tool is pulled from the obligations and the reporting data that is already used by the companies. So as I understand it, is the companies already report some statistical data, which is used currently in this digital tool. Later on, most probably the tool will become more accurate and the employers will be able to use it and to rely on it to either a larger extent. Now let's go a little bit south to Latvia, where the Ministry of Welfare is working on the draft law. It will likely be a new law and not an amendment to an existing one. There is no intention so far to broaden the reporting scope, so to include more companies or companies who have less than 100 employees. So most probably the law will apply to the same extent, at least in terms of reporting, as the directive. So the cutoff line will be 100 employees, and then we will go upwards to 250. The equality body is the Ombudsman's office that has a discrimination prevention department, which most probably will oversee how all of these laws are being implemented once the directive is being transposed. In fact, in Lithuania, we have a similar body, and its function is to oversee that discrimination does not occur in employment relationship. So my guess is that once the directive is transposed, more emphasis will be put on this particular department. And now let's go even more south to Lithuania, where I'm from. And we already know that the draft law has been proposed by the Ministry of Social Security and Labor, but it is not public yet. We know that it is there, that it is being discussed, but unfortunately it's not yet available to the public. From the discussions that we have had with the ministry, it appears that the law does not clearly state how bonuses will be calculated in all of the pay assessment process. So employers should be cautious, because most probably the law will talk about the salary that is included in the employment contract and will be fairly silent on all the bonuses and benefits. So sometimes we know that salary is not the largest portion, or it could be a significant portion, but bonuses may also influence what the employees take home quite a bit. And they may influence the differences between men and women, and they may also influence the pay gap between certain employees. So if, let's say, a manager went to a very expensive training, it should also be taken into consideration. How will that be done in Lithuania? We're not yet sure, but hopefully this summer we will get more clarity together with our Estonian colleagues. And in Lithuania, some requirements are already in force. For example, salary ranges in the job ads should already be mentioned. So if you are looking for a job, you usually see that the pay range is from X to Y, and you may expect that what you will negotiate after you get that job is somewhere between those two numbers. We also have a principle of ad neutrality, which means that employees that are being recruited should be addressed as gender neutral. We are expecting secretaries, both men and women. We're expecting construction workers, both men and women, and so on. And some salary-related data is already available publicly, so the reporting requirements will not be so foreign to Lithuanians, because already if you are searching for a specific company in publicly available databases, you can already find some salary-related data, the median salary amounts, and so on. So it's already quite transparent, and maybe this is something that influenced that our pay gap is a bit lower compared to our colleagues from Latvia and Estonia. We think that more focus will be placed on remuneration policy. Currently in Lithuania, all the employers with headcount of 20 or more should have a remuneration policy. But because they should address pay gap in a specific way, we think that remuneration policy will be the document that will tweak and fine-tune the existing practices. And now let's jump to the last part of my presentation, is how should we prepare? What should we do and what can we do now already? So I think that one of the most valuable processes that you can do in your companies is audit current salaries. And you can do that already during the summer, because you should take into consideration that cycles for changing salaries and for changing remuneration are quite long. They are usually attached to annual evaluation processes. And if you are evaluating your employees in December or in the beginning of 2026, you should already implement the principles of the directive, because most probably you will not have a new evaluation once the directive is fully in force in your respective country. So now you should audit current salaries and verify whether you really have an issue at certain department with certain employees. Is there a large pay gap? Is there a gap that exceeds 5%? And what are the reasons for having the pay gap? Even if we don't have the laws yet, we can find the reasons on what is happening in our company. So definitely include this topic in your work plans and clarify responsibilities for your employees, most probably HR department, talent department, depending on the size of your company. You can also start reviewing recruitment processes and make the job descriptions a bit more neutral if your job descriptions were not neutral before. So basically, these are the initial steps that you can take. If you audit your salaries, you can already go to choosing a methodology if you have quite a lot of pay gaps in your company, on how you will explain or how you will assess and address the pay gap. You should also focus on training the employees that are responsible for decisions related to salary, because if they are not aware of the requirements of the directive, then most probably they will not take that into consideration when actually discussing the salaries and including the salaries in the employees' contracts. And also do not forget the benefits, because the benefits may skew the situation quite a lot. So I think it's time for Christina to take the floor and discuss a little bit what happens in courts.
Thank you, Jovita. Yes, indeed. Let's proceed with an overview of the pay discrimination cases in courts. So when looking at the Baltics, there are both similarities and differences in how such cases are tried before courts. The procedure is various among all three countries. If in Estonia and Lithuania, the claims are first reviewed by special labor dispute commissions. One must note that in Estonia it is optional, while in Lithuania this is a mandatory first step. In Latvia, the disputes are typically addressed addressed at civil courts. There are also similarities in respect to limitation periods, meaning term for bringing a discrimination claim. In Lithuania and Latvia, it is 3 months, while in Estonia, it is 1 year. And the term is calculated from the date on which the employee became aware or should have become aware of the discrimination. Speaking of burden of proof, it is the same in all three countries, meaning that once the employee has presented the initial evidence of the alleged discrimination, the burden of proof shifts to the employer, who must then justify any pay discrepancies if there are such. We will shortly discuss a case regarding this burden of proof in the next slides. But then speaking of legal remedies available for the employees, these are also very similar across all three Baltic countries. If the employee's claim is satisfied, the courts can order compensation both for material damages, such as the pay gap, and also moral damages. In certain cases, the court could also mandate the employer to adjust the equal pay situation, or even impose some sanctions, but it would depend on each situation and jurisdiction. So now let's move to country-specific cases. In Estonia, there are no particular discrimination cases that would be relevant in the gender pay gap context. In fact, there are only few discrimination cases in Estonian courts, and therefore there is no established practice that we could share today with you. However, currently there is a noticeable trend in compensation claims that derive from allegations of workplace bullying, harassment, and discrimination. And it is likely, and we expect that such cases will increase in the nearest time following implementation of the Pay Transparency Directive, as this will increase the grounds on which employees can file claims. A slightly different situation is in Latvia. We have several cases where the courts have assessed claims regarding discrimination on the grounds of sex, which have affected the employee's pay. Today we will present you two of those cases which we deemed relevant in the Pay Transparency Directive context. In the first case, where the final judgment was brought by the regional court, the claimant was a municipal employee at the municipality. She brought an action against her employer, claiming unpaid wages and compensation for moral damage. She claimed that she was subjected to discriminatory treatment based on her gender, which resulted in various situations, but among others, she received lower holiday allowance. She claimed that employees with a lower qualification had 35% surplus to their holiday allowance, while she only 30%. Both the district court and the regional court dismissed the claim in full. The claim landed, and the reasoning was basically the same in both instances of court. Although the employee claimed that she was discriminated and based on her sex, she could not provide any sufficient evidence. Moreover, the employer was able to prove that there were policies in place which said that the allowance, the percentage of the allowance, is determined based on employees' overall performance, which is evaluated each year. And this particular female employee had received the evaluation which allowed her only to 30% allowance, while the other employees performed better, therefore they received higher amount of allowance. And why it is important, we wanted to stress that not always the employee as the weaker party is successful in such cases, as long as the employer has good procedures, instructions, guidelines in place. He can also benefit from these in the courts. The second case is a case of the Supreme Court, and there was also applicant female who brought an action against her employee after she found out that she, as a woman, was paid 17% less than her male colleague, even though they both had the same job responsibilities. The action was based on breach of prohibition of differential treatment and breach of principle of equal pay. And the employee claimed both the compensation for difference in salary and compensation for moral damage. And it is interesting that the first instance dismissed the case in full. The Court of Appeal established discrimination and awarded her 20,000 euros for moral damage, but dismissed the claim for the wage differential. on the basis of expiry of the limitation period, meaning that she brought the claim later than 3 months after the date she found out about the discrimination. The case landed before the Supreme Court, who annulled this judgment regarding moral damages and said that when an employee has not complied with the limitation period of 3 months, even in the case there is a discrimination, which was evident in this case and non-justifiable, the case still has to be dismissed because of lapse of this procedural term. Now let's move to the Lithuanian cases. There are 2 cases which we would like you to present today, and both are Supreme Court cases. Although they do not deal directly with gender discrimination, it might be useful to know these aspects because they might be relevant later on in the light of the Pay Transparency Directive. In the first case, the dispute arose between the Emergency Medical Services Agency and its employees who were transferred from district polyclinic to the emergency medical services following a structural reorganization. And the employees filed claims first with the Labor Disputes Commission, as required in Lithuania, arguing that they received lower salary for identical jobs. The Labor Disputes Commission partially upheld their claims and finding that unequal pay constituted discrimination. Then the case went to the district court, who ruled in favor of the employer, stating that temporary pay differences had an objective justifications due to differing payroll systems, and it was only during the transition period. Later, also the regional court and the Supreme Court upheld the same argumentation. So the key takeaway from this case is that unequal pay for equal work can be lawful if it pursues a legitimate aim, is time limited, and is proportionate. The second case involves a dispute of temporary employment agency employees who were placed at the European Institute for Gender Equality, and they filed a complaint claiming they received lower wages than permanent institute staff. The permanent European Institute for Gender Equality staff was were not employees, but were agents. But still, the court found that, irrespective of the fact that they do not have permanent employees, they have very identical, very similar job obligations, and the principle of equal treatment applies also in such cases, because the nature of the work has to be evaluated. And since the Lithuanian Labor Code and in which the European Directive is transposed regarding posted workers, also requires that temporary employment agencies must ensure that their temporary workers receive the same pay as they would if they were directly employed by this user company in the same position, then it was found that the employer has violated the law. So now we're moving smoothly over to 2 cases of the European Court of Justice. The first one stems from an equal pay claim that was brought in the United Kingdom, and we have also noted a related judgment below in the slides. It is Next Retail Limited. If you would be interested, you can look it up. But basically, the claims were very similar both in the Tesco case and in the Next Retail case. A group of predominantly female retail employees at Tesco claimed that they were paid less than male warehouse workers. And they claimed that the work they perform both at the retail, at the stores, and at the warehouse is of equal value. So the European Court of Justice looked at the case and ruled that Article 157 of the Treaty on the Functioning of the European Union has direct effect in disputes between private parties, and employees can invoke this article directly in national courts. Also, the court confirmed the concept of single source, meaning that where one body, one employer is responsible for pay conditions, then comparisons across different sites, meaning retail stores and warehouse, are valid under EU law. And the last case that we wanted to bring you today is a case from Germany, also reviewed by the European Court of Justice. While the main issue at hand was overtime pay for part-time employees, it still had some pay discrimination factors. So in short, there were the case involved employees who were employed as care assistants, providing outpatient dialysis treatment. They were working part-time, and when they worked hours over their agreed part-time, they were not paid any overtime. So they claimed that since these positions of care assistants is predominantly taken by female workers, there is also discrimination on grounds of sex. And the European Court of Justice held that such scheme entailed less favorable treatment of the part-time workers. And with respect to the discrimination on the grounds of sex claims, the court also established that it constitutes indirect discrimination if it is established that the local legislation disadvantages a significantly higher proportion of women than men, and this discrimination, indirect discrimination, would not apply also to full-time employees. So these are the cases which we think are relevant in the light of the Pay Transparency Directive, and now I give floor to Alice.
Many thanks, Christina. Yes, so let's now turn to your questions. For now, we only have one question actually for you, Christina, because it is also about the case law. So the question is, how do you assess the prospects of case C19/23, Kingdom of Denmark versus European Parliament and Council in the context of the entry into force of Pay Transparency Directive?
Well, the Denmark case, it challenges the minimum wage requirements that have been introduced by the European Union, while this Pay Transparency Directive does not affect the wages. It only refers and includes transparency aspects. So it requires transparency in respect to the pay already established by the companies. What is also important to note that the Denmark case, it is and the legal basis of the directive, which is challenged now, is based on another article of the Treaty of Founding of European Union. It is 153, whereas the Pay Transparency Directive, it is the legal basis is Article 157. So this current directive, I would say it is parallel and does not in any way specifically will not be affected by this judgment that will eventually come into force in respect to the Denmark case. So these are two parallel topics in my view. Thank you.
Okay, thank you very much for that explanation. And as there are no other questions in the comments, maybe I can just ask a question from myself to you. What do you think are the main challenges that in each of the country will be, with the transposition of the directive? And maybe, Haley, you could start and share your thoughts about Estonia.
Yeah, I think that the main challenge will be sort of to overcome the general idea that it is the market that determines the salary, because I think that's kind of transfixed in the sort of the collective mindset that that there are economic and business reasons why various jobs are being paid differently, regardless of this pay categorization and equal value assessment. And so when we're, for example, speaking about this warehouse versus shop clerks, then in those cases also the employers basically said that, yes, we paid more for the shop clerks, for the warehouse employees, because that was the request of the market, while it was possible to hire shop clerks for a lower salary. But that reasoning will no longer be good. Well, it wasn't good until now either, but it's still sort of a common way of thinking about fixing the salaries. And I think that it's always cheaper to discriminate than not to discriminate. So just sort of going further away from this straightly business logic and the market that determines everything, to actually getting into this pay equality and job of equal value assessment I think it will be challenging for the employers.
Thank you, Haley. Jovita, maybe you could share about Lithuania.
Yes, of course. Actually, I have already mentioned one of the challenges, and I think it will actually be the bonuses and benefits, how we evaluate them and how we take into consideration all of these amounts, how we quantify them, and how we can structure all of these payments, because sometimes it happens so that the companies have very rigid categories and very rigid gaps how the salary can be determined. So we have salary from X to Y that can be allocated to a specific position. However, the employee perhaps is worth a little bit more, and he indicates that he will leave if the salary is not raised. The manager is put in a corner. They cannot raise the salary even further to exceed the threshold that has been established by the company. So the manager gives some sort of bonuses or benefits to that employee, where the employee has monetary value and they still stay at the company. However, this skews significantly the entire view, and perhaps other employees who have the same position and basically do the same work. So these situations do happen in practice. In terms of salary categories or ranges, nothing is violated. But if we take a look at the benefits, the situation is wildly different. So I think that it would be a great challenge for the companies who provide a lot of benefits to have some sort of structure on how they are paid, and to evaluate whether a significant pay gap has not occurred in their company.
Thank you, Jovita. And we're at 12 now, but let's maybe stay for a couple more minutes. And Kristina, you could tell about Latvia. And then we also have a question in the comments that I could ask also before we wrap up.
Yes, I would agree with Haley and Jovita that the same issues are would be relevant also for Latvia. And in addition, I think it is also important to know that this new directive will require change of mindset, change of way how we think about disclosing certain kind of information, because currently I would say this is a socially social order. The current social order is that you talking about wages is somewhat taboo. So these transparency requirements will also require the employers and also the employees change the way how we talk about it. So this will be also interesting to watch.
Thank you. Yes, I agree with you. Okay, and then let's take then this question that we have in the comments, and then we can finish the webinar. Haley, I'll ask this one to you. The question is, any opinion if market demand for certain skills, competencies can be used as explanatory factor for pay gap? For example, IT developers are much more expensive to hire compared to accountants, which might be the jobs with the same value.
Yeah, well, on the basis of the existing code practice, I'd say that the market demand is definitely not a good excuse for pay differentiation. So it may well be that IT developers that are for objective reasons are much better paid than accountants, but that will need to be established based on this objective criteria, then showing that I don't know, it takes much more time to get the necessary education and skills. The effort of the IT developers is much higher as compared to accountants. So it will have to sort of be explained by this type of criteria why the IT man is better paid than the accountant, and not the market demand. The fact that it's possible to hire an accountant from the market for a lower salary is not the reason to pay less to the accountant. It must be something else.
I see. Thank you very much, Haley, for that. And thank you very much, colleagues, for sharing your opinions and expert advice. And thank you to all the participants for joining for our webinar today. And see you in other events that we organize.